Well, hello, everyone. This is Institute for the American Worker, Harms and Threats to Independent Contracting Briefing. I am Vinny Vernuccio. I am president of Institute for the American Worker, and I want to thank everyone for joining us, especially our panelists. We will be starting with Jonathan Wolfson, who is the Chief Legal Officer and Policy Director at the Cicero Institute. Jonathan has also led the policy office at the U.S. Department of Labor, where he managed DOL's deregulatory, as opposed to regulatory, deregulatory efforts. He's also a litigator and regulatory attorney at a international law firm, and he was also a policy analyst at the White House Council on Economic Advisors. Jonathan will be talking in depth about the recent rule that came out from the Department of Labor, overlap with some other laws, or conceptual overlap, as I think he's going to put it. And then we will turn to Liya from the Mercatus Center, where she is a senior research fellow. She focuses on entrepreneurship regulations and the gig economy. She has published articles in academic papers and book chapters and media outlets such as the New York Times and Wall Street Journal. In 2016, she was named one of Forbes 30 under 30 in law and policy. She has just published a study that is going to some of that intellectual overlap or conceptual overlap, assessing the impact of worker reclassification and employment outcomes post-California AB5, which did very similar things as the Department of Labor's proposed final regulation has proposed to do. After Liya, we'll be turning to Patrice Onwuka. Patrice is the director of the Center for the Economic Opportunities at the Independent Women's Forum. She co-hosts WMAL-FM's morning show, O'Connor and Company, and she's also a senior fellow at the Philanthropy Roundtable and a Thomas Blakely Fellow at the Steamboat Institute. She has also published articles in Fox News, Fox Business, and PBS. Appeared on Fox News, Fox Business, and PBS, published in the Washington Post, USA Today, Barron's, CNBC, Bloomberg, and other outlets. And she has worked in policy, advocacy, and communication roles in Washington, D.C. for over a decade. We are very fortunate to have such a fantastic panel. And Patrice is also going to tell of some personal stories of the problems and the harms that we've seen from these type of policies, specifically AB5 in California, on specific independent contractors and freelancers. So once again, panelists, thank you so much for taking your time. To the participants, thank you for joining. And Jonathan, can you tell us a little bit about what is in the Department of Labor's independent contracting rule?
Sure, Vinny. Thanks for having me, and thanks to everyone for being here today. And it's a pleasure to be on the panel with such great colleagues. So there's a few big differences between the rule in 2024 and the 2021 rule, which, as Vinny mentioned, I had the privilege of getting to be a part of kind of putting together in the prior administration. And so I think that really the three big differences that folks should be thinking of when they're thinking about the new independent contracting rule that just came out from the U.S. Department of Labor Wage and Hour Division is that in 2021, the rule was focused on kind of the modern reality of independent contracting growing and becoming a key part of the U.S. economy. And the 2021 rule was seeing that as a positive. And the 2024 rule, by contrast, really lives on the belief that independent worker status is generally not beneficial for society, that workers would probably prefer to be employees rather than independent contractors, and that employers who are classifying workers as an independent contractor are more often than not doing so because they're trying to find a way to pay less or in other ways exploit a worker. That's kind of the philosophical underpinning of the new rule as compared to the old rule. And so as a result of that, the new rule puts a thumb on the scale in favor of findings of employee status. And so in the descriptions, in the examples that are provided in the new rule, and all of the tests, every time the Wage and Hour Division discusses the new rule, they really are indicating that almost all of these factors would more likely than not lean in favor of the finding of an employee status and against independent contracting, unless you go into very clear lanes of things that have always been considered independent. So, for example, if I hire an HVAC technician to come and work at my house, there's nobody who thinks that he or she is my employee because I'm simply a homeowner. However, if I happen to own a rental company and I've got 500 units and I'm hiring the same HVAC company, now we're starting to get into what the current administration would think of as a blurry area, whereas the 2021 rule would have thought of those situations as being very clearly not an employee relationship. The second big difference between the 2024 rule and the 2021 rule is that the 2021 rule started its analysis by investigating the legal landscape and looking at how the courts had traditionally done the evaluation. There are multiple factors that courts have over time looked at when deciding whether or not someone is or is not an independent contractor. However, the vast majority of those opinions across the country, as you look back in time, going back to the 1940s when the statute, the Fair Labor Standards Act, was actually written, and then these questions started coming up. In almost every one of those cases, what we did in the 2021 rule is we evaluate all of those cases and point out how in almost every single case, the courts really based their decision not on all 6 of these factors or even some additional factors, but really on whether or not there is control and opportunity for profit or risk of loss. And those 2 factors are almost always dispositive when you look at those court decisions. And so the 2021 rule relied on those 2 factors first, and only in circumstances where those factors either departed from one another or it was not clear what the answer, independent contractor or employee status, was based on those 2 factors, then you would turn to the other factors and do this multi-factor balancing test. The 2024 rule rejects this conclusion. Now, I would argue they didn't carefully refute the case law research that we had done in the rule that we had put together in 2021. That's a conversation that we can have during Q&A if you want. But ultimately, the new rule claims that it is improper to reach a independent contractor or employee status determination by simply looking at those 2 factors. You have to use at least all 6 factors that the rule ultimately lays out, and that no one factor can be more important than the other, or at least so they claim. And so ultimately, the new rule says you can't rely on simply 2 factors, but you have to do this 6-factor, multi-factor balancing test and try to come up with what the answer is. The third big difference between the 2024 rule and the 2021 rule is that the 2021 rule aimed to allow workers to perform work on an independent basis, even if that work was similar to the work done by the business. So, for example, trucking companies in the United States have for a long time worked with independent owner-operators. These are individuals who own the tractor that sits on the front, and then they pull trailers for various companies across the country. And this has been a relationship that has existed for decades. It's not something that is kind of part of the modern new economy. This isn't just Uber and Lyft. This is something that has existed for a long time. The 2021 rule pointed out how the integral factor that has become a part of the 6-factor test was really something that came out of what lawyers call a scrivener's error, where people looked at what was really a discussion of how integrated into an assembly line a worker was, and whether that person was integrated into the production of the product. And ultimately, the court changed that word from integrated into integral, which integral just means important. And ultimately, the 2024 rule explicitly rejected our framing that we had in 2021, where we said this scrivener's error means that factor should go back. And so it really is much less important in the analysis, because simply deciding whether or not someone is on the assembly line next to someone else is generally not the question when you're looking at current independent contract or employee status. But it was back in the 50s and 40s when some of those decisions were coming out. But by rejecting that factor, you're able to evaluate whether or not the relationship looks independent. In the 2024 rule, they explicitly reject this framing, and they embrace the integral factor as a key determining factor for whether you are an independent worker or an employee. So while the rule doesn't explicitly call this factor any more important than the others, the reality is every time you go through examples that the new rule is putting out there, every time you look at their analysis of the various factors, this job or is this task important to the business? Is it integral to the business? Has become in some ways almost the most important factor that the department is now using and turning to. Now, why is that important? Well, because ultimately the Department of Labor is saying and has said from the beginning that they do not have the authority to impose AB 5, Assembly Bill 5 from California, which imposes the ABC test on independent contractor and employee discussions. However, the second factor in the ABC test, whether the job is outside the course of the hiring entity's business, looks a lot like the integral factor as the Department of Labor is describing it. And so I think ultimately the real concern that I have with the new rule is that we are moving toward the ABC test because the integral factor really does open that door, and it makes it so that any business that is hiring an independent worker to do something that is very similar to the task that that business is already doing is going to be at risk of having their workers found to be independent contractors. So I think those are the most important things to kind of think about when we're looking at the 2021 rule and the 2024 rule. And I'm sure we'll have lots of chance to have additional conversation in the Q&A.
Great. Thanks, Jonathan. That was a fantastic recap and a great transition to Liya, who is going to talk about the harms of AB5 and what we can expect to see if this rule does fully go into effect. But before we go there, I'm already seeing Q&A start popping up. We will have time for question and answer at the end. If anyone does have a question, please look to the Q&A box at the bottom of the Zoom screen and type it in, and we will get to it after the panelists. Also, if you see the chat box, we will be linking to a lot of these studies and these articles. We already have a link to the rule itself and some of the I4AW materials that we've already put out. So once again, check out the chat feature right now for those links. If you do have questions, please put in the Q&A. And Liya, I don't want to be cheerful about this, so tell us what's going on in California.
All right. Well, hello, everyone. Thank you for joining us today. And thank you, Vinny and the Institute for the American Worker for putting together this event. As was mentioned, I'm an economist at the Mercatus Center at George Mason University, and I focus on independent work, labor policies, and the overall changing nature of work. So we did this study along with my co-authors, Christopher Kaiser, Paulo Suarez, and Vitor Mello, a study on California's AB5, which is the first empirical investigation of California's AB5. And our motivation for doing this is because, as many of us know, there is a growth of federal and state reclassification policies that attempt to change the regulations or change policies to make it harder and more difficult to be an independent contractor or self-employed individual in the United States. However, there are no empirical investigations on what the effects of those policies and regulations are. So we took on this study and used California's AB5 as our basically what we study because it introduced the strictest legal criteria for being an independent contractor in the United States to date. So that's what we decided to study. And our question is pretty simple. What happened in California post AB5? And so I'm going to leave you with 3 key findings. And I think Vinny and others will make the full paper available, and then my Substack post on the summary of the results available as well. But 3 key findings. 1, self-employment and overall employment significantly decreased post AB5. 2, occupations with a high level of self-employment saw greater reductions in employment. And 3, we find no consistent or robust evidence that traditional W-2 employment increased post AB5. So let's unpack those a little bit. So self-employment and overall employment significantly decreased post AB5. Our findings suggest that self-employment fell by 10.5% on average, while overall employment fell by 4.4% on average. Now, our findings also suggest that occupations with a greater prevalence of self-employed workers saw greater reductions in both self-employment and employment. And so that, for example, are occupations like farmers and ranchers, chiropractors, repairers, and so forth. And as just one example, self-employment fell by almost 1/3, so 28% to be exact. And overall employment fell by as much as 14% for those occupations that had a high prevalence of self-employment. And then the third kind of unpacked key finding is that we find no robust or consistent evidence that traditional W-2 employment increased post AB5. And so what that means essentially is that our findings imply that AB5 did not necessarily lead to more W-2 employment, as was intended by lawmakers. And then we do find in one case in where we see an increase, a statistically significant increase in W-2 employment, but this increase was not large enough to offset the significant decrease in self-employment, which thereby resulted in an overall reduction of employment in California. So overall employment in California consists of both self-employment and W-2 employment. So in one specification, we saw a statistically significant rise in traditional W-2 employment, but in that same specification, we saw a significantly larger decrease in self-employment. So it was not that, so that led to, in those cases where we do even see an increase in W-2 employment, they are not large enough to offset the huge decreases that we see in self-employment, which resulted in overall declines of overall decline in employment in California post AB5. So overall conclusion is that the findings in our study suggest that AB5 did not simply alter the composition of the workforce as intended with, okay, here's a bunch of workers, let's make more of them employees and fewer of them independent contractors. So we did not find that in this study. Instead, we found that AB5 is associated with a significant drop in self-employment and overall employment in California. One shorthand way to kind of understand the magnitude that I cited with the 10.5% on average, self-employment fell by 10.5% on average, is that on average, 1 in 10 independent contractors likely lost self-employment opportunities, while there is no evidence of accompanying increase in traditional employment opportunities. Now, I get some questions about, okay, well, why was this the case? Our paper does not, and due to data limitations, can't test exactly why we find we found these results, but there's a couple mechanisms that I'll walk you through right now. So first, it could be the case that employers may have hired some, but not most independent contractors as employees, while other employers may have stopped working with their contractors based in California altogether. So that could be one thing that happened, which would have led to a decrease in self-employment and employment overall in California. Second, some employers may have extended employment opportunities to independent contractors who then decline these offers. So this could happen for workers with a strong preference for flexible hours or for working with multiple clients. And so they may have not wanted to work as traditional employees with one company. And then third potential mechanism is that some small business owners may have been forced to shut down if they relied heavily on independent contractors and then could not afford to hire them as employees, or stopped working with independent contractors because of fear of compliance. So this was highlighted by interviews of small business owners in the wake of AB5 by outlets like the New York Times and LA Times. Kind of did some profiles of these. Okay, so what do our findings suggest for the Department of Labor rule that Jonathan just unpacked and talked about? So what we can draw from this is that the Department of Labor rule may lead to significant decrease in self-employment and overall employment nationwide. And we might expect, again, that occupations with a greater prevalence of self-employed workers will see the largest declines in self-employment and overall employment. And then further, it's actually not clear whether the Department of Labor rule will definitively lead to an increase in traditional employment as intended. So in short, our study suggests the Department of Labor rule will face significant limitations in meeting their intended results. And then the rule might have additional negative consequences that were not accounted for in the DOL regulatory impact analysis. So with that, I'll end it there and happy to answer some more questions in the Q&A.
Great. And if you do have questions, please ask them in the Q&A box. We do have a couple logistical ones that came in. First, Liya's study and her Substack are in the chat, so I'd reference everyone to, or ask everyone to reference that. their links are there, and we will be sending that out after the webinar. Also, a question on, is the webinar going to be recorded and available? And the answer is yes. We will also share the recording, and it's also on Facebook Live right now. So if you miss anything, there'll definitely be opportunities to circle back. So with that, Patrice, I know that you've talked to a lot of freelancers and independent contractors, not just in California and across the country. What are you hearing, and what are the obstacles that they are facing?
Great. Well, hello, everyone. Thank you, Vinny, for pulling this together. And it's been great to be on this panel with Liya and Jonathan. The first reaction is a lot of concern and confusion, I think, among independent contractors who worry that what happened in California is going to be nationalized. And so I'll get into what I think we can expect next. And what's very worrisome. But to pick up where Liya left off, I think her research is absolutely critical and needed. And it adds the ammunition to a lot of the anecdotal evidence that we've relied on so far coming out of California, but also what independent contractors nationwide have told us they're worried about. One of the big pieces that I took away from her research is flexibility is not a commodity, but a necessity for many independent contractors. And that certainly hits some demographics more than others. At Independent Women's Forum, we are an organization, a policy organization that's looking for those solutions that particularly affect women. And over half of freelancers in this country, 60 to 70 million people, whichever definition you go with, are women, and they're looking for flexibility, whether that's because they're balancing caregiving for their children, maybe an aging parent or a sick spouse. Maybe it's because they have their own health conditions that preclude them from being able to work in a traditional 9-to-5 job or in W-2 employment. And it's so interesting, an Indeed survey last year of women who transitioned from full-time traditional employment to independent contract work, or part-time or full-time, they did it precisely because of flexibility and precisely because they could not just that they're choosing not, but that they could not work in traditional employment. And part of what we do at Independent Women's Forum is not just looking at policies and analyzing policies, but we've launched a storytelling campaign to give those anecdotes of individuals who actually have been harmed. And we talked to many people in California. And one of those stories, if you go to our Chasing Work link, I think we will have it in the chat. But Monica Wyman, who was a 3-time breast cancer survivor. She was a florist, had her own small business in California, and she was able to raise her family, beat breast cancer 3 times because of independent contracting. Well, her business pretty much all but folded after AB 5 was implemented. And that is an example, and in part, not just because of the difficulties that she had retaining clients, but to Liya's point, because she was a small business that depended on an independent contract workforce. And I think that's what we're going to see. We're going to see small businesses who depend on those contractors because, frankly, they can't afford, or they don't have the business, the contracts, the work to sustain having someone on full-time or even part-time. Maybe their projects, they're needed are project-based or event-based, like her event planning business and florist business. So I think there's a lot of worry about those small businesses and about women in particular losing the flexibility. The other folks that we have certainly spoken a lot to are older Americans. People who are seasoned in their careers, they have experience, they've served for decades in different industries and certainly have a lot of expertise, but they find that particularly in California, age discrimination keeps them out of opportunities for full-time employment, or they have health conditions and they need to schedule work projects around their own health conditions. So, we talked to a senior freelance writer, senior freelancer who was in the transcription business, and she built a great career. And Shertrain, she built a great career, 74 years old. And she said, listen, I can do my online transcription work as an independent contractor. As soon as AB 5 was implemented, she lost all of those applications. She lost all of the work, particularly from out-of-state employers who wanted to be in compliance with AB 5. And so when I think about what the impact of something like the Department of Labor rule, or even states that are implementing more stringent regulations on independent contracting, there's no running away from it. And you may think, well, if I'm in another state, that may not impact me, but employers are going to be looking at compliance, and they're going to be thinking, you know, how do we ensure, and I should say, not just employers, but people who hire independent contractors are thinking about being in compliance with this law. And so it's not surprising that I think we will start to see some of these negative impacts pretty quickly. So to the point about what happens next, and I will just say that Independent Women's Forum, we submitted public comment in support, not in support, sorry, in opposition to the proposed rule by the Department of Labor. And we highlighted a lot of different things, like the impact on women specifically, like the impact on small businesses, quantifying that, asking the Department of Labor whether they have considered the likely impact on small businesses on different individuals. We didn't see that necessarily addressed in the final rule, but we are worried that there's going to be a lot of confusion around this. And in the short term, I think what happens next is two things. Number one, that issue of compliance. Companies are going to want to comply with the rule. We understand that there may be different avenues, whether the rule it's supposed to go into effect on March 11th. There could be lots of roadblocks to that happening from a legal perspective or a legislative perspective. But in the interim, HR professionals, HR communities are absolutely sharing with their clients that this is actually the new regulation. And so you're going to start to see a company say, okay, well, how do I stay in compliance? Because I don't want to run afoul of these new regulations. And unfortunately, it wouldn't surprise me if we start to see some of those negative impacts that we saw in California, and some of those negative impacts that Liya talks about is potential for potentially happening nationally to start to happen as employers figure out, okay, what do I do with my independent workforce? And you know, I think the other part of it is, will the Department of Labor start to investigate and look for these examples of misclassification? Will they start taking compliance actions against different companies? I think that could have a chilling effect on companies that hire businesses big and small, which hire independent contractors. So we are concerned. We are absolutely concerned that this is going to have a devastating impact on entrepreneurship in this country, on flexibility in this country, and on those who depend on freelance work and flexibility, like women, like older Americans. And we're looking forward to seeing what can happen next. But we hope that this would not become something that we're hopeful that a lot of the devastating impacts that happened in California do not become nationalized. But unfortunately, the signs point to that being the case.
Great, thanks, Patrice. And for everyone, I put Patrice's, our Independent Women's Forum Chasing Work series on independent contracting, where there's a lot of these examples. That is in the chat. And once again, we will be following up. And Patrice, yeah, want to commend you again on the great comment that Independent Women's Forum submitted on the IC rule. I believe you guys were cited, 6 times in the footnotes. So you made them work for it. So thank you. And once again, thank you to our panelists. Moving over to Q&A, we've already got I've got a couple questions, but want to address some of the questions that have already come in. And Jonathan, I think some of these may be geared towards you, but obviously, Patrice or Liya, please feel free to chime in. The first question was, how does the 2024 rule differ from the rules before 2021, so the pre-Trump era?
Yeah, that's a good question. And I think that there's a couple key things that people should keep in mind. One is there really wasn't a rule before 2021. One of the things that we discussed when we wrote the 2021 rule was, and it's in the, it's in the preamble to that rule. And then the current administration, they follow that exact same analysis. We say, one of the challenges is everything's being done by guidance and just kind of by enforcement actions. And that doesn't seem to be the right way to differentiate whether someone is an employee or an independent contractor. If you really are trying to help grow your economy, you don't want businesses, to Patrice's point, to not know whether or not they are putting someone in an employee or independent contractor situation. So it was, first of all done by guidance. Second of all, I think that, before the rule that we put out came out, the guidance was not as kind of structured in a way to put a thumb on the scale in favor of employment status. I think that the 6-factor test was still there, but I think most of the discussion was definitely a little more forgiving of an employer making these decisions. And I think that while there was still an ethos in the administration that was in place prior to the Trump administration that they wanted to cut down on misclassification, I think that the language that was used in most of those guidance documents would indicate that you really did need to balance all these factors, that you couldn't have one factor control, that ultimately lots of these relationships, there'd be some forgiveness if people misclassified accidentally. I think that was kind of the attitude of, we're going to try to help people know what the department doesn't want them to do, but we're not going to bring a lot of enforcement action. And I think to Patrice's point, one of the big differences between putting it into an actual rule and saying we're going to actually go out and start enforcing is the potential chilling effect that has on the businesses that are out there. So I think those are kind of the big distinctions that I would point to between the guidance from the Obama administration and the final rule from the Biden administration.
Great. Thanks, Jonathan. Patrice or Liya, anything to add? Okay. One more, and this comes from Karen Anderson, who, if you may recognize the name, I know Patrice is smiling, nodding her head. I know Independent Women's Forum has worked very closely with Karen, who is head of freelancers against AB5 in California. And her question is, Lorena Gonzalez, the author of AB5 in California, says that the new Department of Labor rule supersedes Prop 22, which exempts Uber and Lyft from AB5. Does the DOL rule supersede all state labor laws, and how is it enforced?
So, Karen, great question. I think that she's wrong in the sense that federal regs don't get to supersede state statutes where the state statute is different, right? So this is not a federal preemption issue where the entire field of employment law or of worker status is controlled entirely by the Fair Labor Standards Act. There's also that she's not right in the sense that California can have different laws on the books than for independent contracting than the federal regs. She is right in the sense that if Uber and Lyft thought they had a get out of jail free card because of Prop 22, that assuming that, and this I think would be the position that Patrice, Liya, Vinny, and I would all take, that AB5's ABC test, so the 3-factor test that California uses, is similar enough to the new federal regulation that even if there was a special exception that said, yes, we understand that Uber and Lyft got carved out by the people of California, now the federal government can come in and say, well, we think that Uber and Lyft are transportation companies. I know there's a fight over whether that's true or not, but we're just going to go with what the Labor Department could say. They're transportation companies. They're hiring people to transport people and goods as independent contractors. That is integral to the business model that they have developed. Therefore, those workers are in fact not independent. They look a lot more like employees. If you go through some of the other factors, one of the ones that Department of Labor intentionally put in was talking about having GPS tracking as a way to indicate that someone is not in control of their business. Well, I think we all know that Uber and Lyft would have a hard time saying that they aren't GPS tracking all of the vehicles that are on the road. So if I were Uber or Lyft, I would not be thinking that Prop 22 has protected them. It protects them from what California has done. It doesn't protect them from potential investigations and potential federal litigation that could come. And I think that's, one thing I would just take a step back. And this goes to Liya and Patrice's point about enforcement. If you're a business, you don't just worry about enforcement from the federal government. Individual workers have the right to file a lawsuit against you, including as class actions. And so even if there was some sort of tacit or explicit agreement between the federal government or a state government and a particular business, that their business model was not going to be subjected to the interpretation that they are in fact misclassifying their workers, the workers would still have the right to bring those same claims to court. And the more opportunities you have to say, look, here's all these other factors that you, the court, need to think about, that if I'm a business, if I'm advising a client as an in-house lawyer, I would say to them, the risk of you being found to have misclassified is much higher, because now we've got all these factors that are supposedly going to be important to the analysis.
Great. Thanks, Jonathan. Liya, I'm going to go over to you in a second. I think you can cover this question. I'm going to paraphrase it. We've heard it's not the same as the AB5 test, but we've also heard it'll have similar effects. With the statistics you were able to glean from California, the drop in self-employment and the non-corresponding increase in actual W-2 employment, what do you think would happen if that type of rationale, which the DOL, which the Department of Labor is trying to do across the rest of the country, what do you think that translates to if this rule does go into full effect?
Yeah, that's a great question. So I see Tom's question here, and I think his part of his point, Tom, I guess part of your question is that if nationwide workers and companies have no place to run, right? That's what you said. Whether there's nowhere to run if the rule is nationwide, is it possible that is it possible that companies will be forced to convert independent contractors to employees? Therefore, we might see an increase in traditional employees that we didn't see in California, because in California, companies could just stop working with independent contractors in California only. So great question, Tom. It's possible that we'll see some reclassification from independent contractors to employees with the DOL rule, perhaps more than we saw with California's AB5, based on what you pointed out. However, we might also expect greater negative consequences on independent contractors and self-employed individuals. So, for example, after California's AB5, there were articles about how many truckers were leaving California because of California's AB5 and going to different states where the rules were not as stringent for truckers. For self-employed truckers and independent contractor truckers. Well, if they have nowhere to hide, if the rule is nationwide, those truckers may have lost their income opportunities overall. So, it's hard to tell exactly what the impact will be of the DOL rule. And I just want to caution everyone from kind of drawing final conclusions about the DOL rule based on our study. So it's possible that we might see more workers being reclassified as employees with a DOL rule, but it's also possible, and maybe we would see both effects. It's also possible that the impact and the effect on independent contractors and self-employed, the negative effect would be far greater than we saw in California with California's AB5. Now, I want to point out one more thing that was addressed. So in California, there are many occupations that were exempt from the rule, many professions and occupations that were exempt from the rule. The DOL rule doesn't have these occupations that are, and professions that are exempt from the rule. So in that case, we might, the effect of the rule is expected to be more widespread than AB5 was in California. So that is a concern for the negative consequences that we might see nationwide, because a lot of professions and occupations weren't impacted by the rule. And so they got spared through the whole thing, and they didn't see the drops in self-employment and over-employment and so forth. But there's no way the DOL will have those. They can't legally provide those exemptions for professions and occupations. So in that case, we might see the negative consequences of the DOL rule be far more widespread than it was in California.
Great, thank you, Liya. And just to note, the bill sponsor, Lorena Gonzalez, who we previously referenced, she was the one that introduced a lot of those exemptions, because even she realized that California AB5 went too far. Patrice, question for you. What is happening now? I've been referencing the rule going into effect. It's been promulgated, it should have final rule, but it hasn't fully gone into effect. Is anyone pushing back on it? And what is happening right now?
Sure. So the rule is supposed to go into effect on March 11th. We have already seen, I think I mentioned 2 tracks are likely, the legal track, legal pushback, as well as legislative or congressional pushback. On the former, we've already seen the Pacific Legal Foundation file a lawsuit. I believe it's a class action suit representing the group, Kim Caven's group of freelancers group. And so that's one of the lawsuits that I think we will see. We'll probably see other potential lawsuits. Let's not forget that the original Biden rule had been stalled by federal courts because of a different pending lawsuit that could be reintroduced. And so I think we're going to see this law rule get tied up in the court system, and hopefully put a stay on the implementation and the execution of this rule. The second piece, and which is really exciting, is Congress's role here. Obviously, a lot of conservative free market organizations tend to worry about the government overreach of agencies like the Department of Labor in lots of different rules. We've seen Department of Labor take on franchising through joint employer, for example. And so Congress has a role to play here. And we've already seen in the Senate, Senator Bill Cassidy has announced that he's going to be using the Congressional Review Act to overturn or rescind the Department of Labor rule. We might see other of his colleagues, either in the Senate or the House, join on to that effort. But that's, I think, an opportunity for individuals to support, to make sure that they're able to say, hey, wait a minute, it's important to our legislators. This is an important issue for us. So be on the lookout for when different groups, when these members of Congress announce use of the CRA, as well as I'm sure there are going to be lots of groups. I know at Independent Women's Forum, we have our sister group, Independent Women's Voice. And so lots of groups have partners in arms that are able to kind of galvanize support behind stuff opportunities like that. I'm trying to keep it C3 compliant, but yeah, I think we'll see 2 lanes: the Congress stepping in here, as well as the legal aspect of it.
Sounds good. Thanks, Patrice. And we do have a question that looks like it's a good follow-up to that. And this is from Mike Ruby, who is asking, on the DOL rule, do the buyers of IC services have stronger grounds for suits than IC themselves? So I think he's asking about standing, and open that up to the panel.
So I think if you're talking about whether they have stronger lawsuit potential against someone for hiring them, probably not. But the people who are buying the services, they may have good standing to try to say, hey, like, we're trying to access these services. So if a bunch of, say, Uber users were to say, hey, we can't access these services, assuming the courts will give them standing based on like a potential loss of the services they would get, then their story sounds a lot better, right? Or the workers themselves bringing the suit sounds a lot better than Uber or Lyft, for example. And I think one just important caveat to remember, Uber and Lyft, while they are the most kind of in our faces entities that are doing independent workers, are, all the platform companies, Uber, Lyft, DoorDash, those groups make up a tiny percentage of the independent contractor workforce in the United States. And the vast majority of these people are making significantly more money, and they're doing it much closer to full-time work, and they're piecing together a lot of contracts. So I think it's just important to put that fact on the table.
Great. Thanks, Jonathan. Patrice, question back over to you. And I'm going to have a first an aside. Where did the AB5 sponsor go when she prematurely left the legislature in California? And the next question is, what is the union and labor motive behind this?
So it escapes me where Lorena Gonzalez went. I know Kieran Anderson, good friend. She might be able to drop that reminder. I think she wrote a piece for us at IWF about that. But listen, independent contractors cannot be unionized. And that is, I think, where big labor, which has seen unionization levels recede over the past few decades to probably their lowest levels over the past few years. They see the what, 65 to 70 million freelancer workforce in the United States as, you know, a ripe field to be plucked. And so if you're able to force people, independent contractors, to become employees of a company, then you can get them to try to unionize their employer, their business, their workplace. And so this is, it's sad to say, but I think a lot of this is driven by the unions and big labor. And Lorena Gonzalez is a great example of that, certainly a strong union advocate. And I think in Julie Su, the Department of Labor Secretary, she's also a very strong labor supporter, and her background reflects that. And we have the president, in his words, the most union-friendly president in history. And so this is absolutely an effort to try to increase unionization levels and expand the power and reach and, frankly, coffers of big labor.
Great, thanks, Patrice. And I will quote Karen here. That's the answer that I was looking for. Lorena Gonzalez now heads the California Labor Federation, which represents 1.2 million workers and 1,200 unions in the state. And they were one of the chief backers of AB 5 in 2019. So interesting. Also, I don't think this is a question, but Liya, you got a shout out that your AB 5, that your point about AB 5 exemptions not being part of the DOL 6-factor test cannot be underscored enough. Thank you, Peter List, for that comment. Going back, we had a couple more questions on the rule, and we are running short of time, but we still have time for a couple more questions if people would like to put those in the Q&A. Does the 2024 rule require that you meet all 6 factors of the rule, or just a majority?
Well, so that, unfortunately, it's not even a majority. It is any factor could be enough. This is the challenge with a multi-factor balancing test. Multi-factor balancing tests are lawyer ways of saying, we're going to throw everything at the wall and let a judge just decide, which, to Patrice's point, means as an employer, you have a really hard time knowing in advance what the outcome is going to be, which is part of why we tried to narrow it down to 2 factors in the 2021 rule. I think that the key here is that if any one factor shows a really strong indication of employee status, for example, your work is very similar, it's integral to the work that the business is doing, then it's going to be really hard to overcome the presumption that's created by that one factor that you're going to lose. Now, technically, is that true? No, technically, the court is supposed to look at every single factor. But practically, when you look at the cases that have proceeded, if an individual has 1 or 2 factors that are kind of weighing really strong, more likely than not, the courts are going to fall in favor of finding that person to be either an independent contractor or a employee based on those 1 or 2 factors. So it's not even a majority.
Great, thank you, Jonathan. Liya, a question for you. It's a little bit long, but I'll try to make it a synopsis. It's asking about the recent article today in Bloomberg in response to your paper. And do you have any responses to the criticisms of the sources that are usually against independent contractors? Specifically, the Professor Michael Reich, who says your analysis doesn't take into account the economic trends in the state prior to the policy change on worker classification. And essentially, I think it boils down to the high number of job losses that California is seeing as opposed to the rest of the country anyway.
Yeah, thank you, Kim, for those questions. So there was a Bloomberg Law article this morning that highlighted our study and then cited two comments or criticisms of the study. So the one comment by Michael Reich says, these findings are not really causal. In that case, this is true because we do caution in the study that our estimates are not causal due to the data constraints. However, we don't dismiss the study because we've done our best under these constraints to ensure that the associations we find are robust. So as such, the precise magnitude of our point estimates as less robust than the statistically significant associations and overall consistent patterns that are shown in our data. So that is why our primary takeaway is essentially that AB5 was intended to increase traditional employment, yet we find no consistent evidence that it did so. But we do find consistent evidence that self-employment declined significantly, thus resulting in overall employment declines as well. And so I would also point out that this is the first empirical assessment of California's AB5. And this is a pattern that in any way that we ran the specification that we've seen these robust statistical associations. And so, taking, with caution that we can't 100% say that that California's AB5 100% caused these indicators. We do feel confident in our results that we find, these robust statistically significant associations and consistent patterns in our data. The second comment about, which is from EPI, Economic Policy Institute, that there's no, there's not really a story where traditional employment would fall. That comment is not true. There are stories where traditional employment would fall as a result of AB5, and we've seen these highlighted by news stories, or perhaps I think maybe Patrice, one of the stories that you've highlighted as well. So why would traditional employment fall as a result of AB5? So here's an example that was highlighted in some of these news articles. Small businesses might heavily rely on independent contractors, but might also employ 1 or 2 or 3 employees. If the small business closes or shuts down as a result of AB5 and not being able to work with those independent contractors because they heavily rely on independent contractors, we see that business shut down, which means those employees are also become unemployed. So those are the sort of stories where we might see traditional employment fall. There are others, but we're coming close to the time, so I just wanted to highlight that it's not true that there are no stories where traditional employment would fall in California as a result of AB5. That's just one example that we've seen in stories highlighted, and maybe Patrice has others, that she wants to highlight as well.
Yeah, we do have some stories on our Chasing Work website that speaks to that issue. And just a kind of a postscript to Liya, what you're saying, what you also talked about in the research is not just the decline in employment or increase in unemployment. I think it's also the impact on labor force attachment. And so if you could not be turned into an employee because your personal circumstances preclude you from doing that, that means that you're dropping out of the labor force entirely. And we have to wonder then what happens to those individuals. That raises other public policy questions around our social safety net and increasing the amount of people who are just not, their financial needs are not being met. So it is very worrisome about the impact of labor force attachment, particularly among women, particularly among older Americans, when they're not able to work, whether as an independent contractor, and have multiple clients, or their small businesses have to shut because of that. And that I don't think we've seen addressed by the Department of Labor either.
Great. Thank you, Patrice. Thank you, Liya. Karen Anderson also just sent a link to more AB5 stories. I have put those in the chat. This is a hot topic. We have more and more questions rolling in. Unfortunately, I do not think we're going to have time for all of them. If we do not get your question, or if you have any follow-up questions, once again, we will be sending out an email. If before that, you can email me directly, and I will send those questions to our panelist. My email is Vinnie, VINNIE, at i4aw.org, Vinnie at i4aw.org. Let's see if we can get through 1 or 2 more. One question came in, and it deals with the Supreme Court now looking at Chevron deference. So how does the Chevron case currently at SCOTUS have any potential impact on the DOL test? And I'll go back to my old law school joke. There's 2 kinds of people in the world: those that don't understand Chevron and liars. So with that, Jonathan, I'll just hand it over to you.
Well, I'll try to pretend to be a liar. I think the thing I can tell you is we have no idea what the court's going to do on Chevron. I think that, and I've said this before, I think that there's going to still be some level of deference that the courts have to give to the agencies. Whether I think that's correct from a constitutional perspective, different conversation. But I think practically that's where we wind up with something like that, which probably means that for the next decade, the admin law students and practitioners are going to be fighting in federal appellate courts over what the contours are. That said, I think that part of the reason that this rule took so long for them to put out the kind of the final rule was an anticipation by the current administration that there will be a crackdown on Chevron. And so there's a lot of additional ink spilled in the final rule trying to explain the justification. Whether they did that or not is a totally different question, but I think that that was an attempt. I think that this rule, like most rules that have come out for the last decade, will have a hard time passing a world without Chevron if you find a court that disagrees with the analysis. But that's going to be the world we're going to be in. I think that this rule, like so many others, is going to have a hard time passing Chevron deference if Chevron deference doesn't still exist.
Great. Thank you, Jonathan. And I think we are getting close to time here. So once again, I would like to thank our panelists, Patrice, Jonathan, and Liya. Fantastic stories, great research, and wonderful analysis on the independent contract rule. Once again, this is Institute for the American Workers presentation on harms and threat to independent contracting. We will be doing follow-ups with all the links that are in the chat. If you do have questions, feel free to email me. I will send them to our panelists, vinny@i4aw.org. And please stay tuned for more briefings and publications from Institute for the American Worker, from the Cicero Institute, Independent Women's Forum, and the Mercatus Center on issues affecting women, affecting independent contracting, and entrepreneurs. So once again, thank you very much, and we will be following up soon.